The injuries you received from a careless doctor were horrendous, awful. You suffered horrible injuries, and now you learn that the doctor has only a limited amount of available insurance. When they tell us that, is there any way for us to prove that the doctor may have more insurance available? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now here's the scenario. You suffered terrible injuries as a result of a doctor and hospital staff violating the basic standards of medical care. And now you bring a lawsuit against the doctor and the hospital, seeking compensation for all of the injuries and all the harms and losses that you incurred. And now you learn after starting the lawsuit that the doctor has a limited insurance policy of only $1.3 million. Now, for those of you watching, you might be thinking, oh my God, $1.3 million is a tremendous amount of money. And don't get me wrong, it is. But it turns out that your injuries are worth far more than that $1.3 million. So now, the doctor says through his attorney, hey listen, the doctor only has this available amount of insurance. What do? We ask the doctor to prove it. Prove that that's all you have. Prove that you don't have any additional insurance coverage, umbrella coverage, excess insurance coverage, coverage through the hospital, coverage through your medical group. Prove it to us. Now again, you might be asking, well, how does the doctor prove that? If they've only had an insurance policy of $1.3 million, how can they prove that they don't have more? The way we do that is by asking the attorney for an affidavit from the doctor. Now, what's an affidavit? An affidavit is a sworn statement where the doctor swears that he has no additional insurance available. He's done a search, he's done a check, this is the only insurance that he had, and this policy was in effect for this time period. So he is basically swearing to tell the truth that this is the only available policy. He doesn't have excess insurance. He doesn't have any additional insurance, no additional coverage through the hospital, through his medical group, or anywhere else. And now we keep that in our file because later on, if we now learn that there was additional insurance coverage available, now the doctor has lied about it, and we relied on that doctor's sworn statement in going forward with a case only against him. Because if we do find out later on that this doctor did in fact have more insurance, it could have changed our tactics, it could have changed our strategies. We could have brought in a different person, a different company, a different legal corporation that would have also participated in this lawsuit. And it might have altered the amount of compensation we were able to achieve for you, assuming we were successful. So it is critical to get the doctor and his attorney to actually prove that that's the only available insurance coverage that they have. You know, I realize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.